Good morning.
The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Good morning, Mr. Zimmerman, when you're ready.
Yes, judges, good morning. May it please the court. Frank Trey Zimmerman, counsel for the McCardle Family Partnership. And I see the shot clock is right. I'd like to reserve 7 minutes for rebuttal.
Yes.
Briefly to roadmap, I'll do a brief factual presentation, then we'll get to the district court's errors. Initially, I'd submit this is a matter of substantial importance for the state of West Virginia and oil and gas jurisprudence, because if the district court's ruling is upheld, it will substantially disrupt royalty practices and mineral ownership practices within the state. This matter arose because after 8 years of oil and gas production by Antero without any payment to the McCardle Family Partnership, MFP received a 1/16 royalty check from Antero that was unannounced, with 500 pages of documentation, and it evidenced that the estate had been produced and monetized from 2012 to 2020. So to speak, the check just arrived. First and foremost, an overriding royalty is a royalty paid out of oil and gas production. It's typically created when an operator upsells assets or when services are performed by a third party. Following receipt of the check, MFP questioned Antero about how the payment was calculated. How many acres were included within the check? Was it right or was it wrong? And clear answers were not received. That's within the joint appendix at pages 78 to 83. And why is that important? Because a decimal interest in a well demonstrates how many owned mineral acres are being produced. There's a basic formula. You take the number of acres in production, you back that into the entirety of the drilling unit of the production, you multiply that by the royalty rate, and that gives you your percentage of the well, so to speak, how you are being paid, what is being produced, and what is not being produced. Specifically here, MFP asked, among other questions, the Hudson lease totals 490 acres. I'm only being paid on 266.9 acres. How is this explained? That's within the joint appendix at page 72. If we step back in time, in the 1960s, a number of wells were drilled in West Virginia as part of a drilling program. Those included the Hudson, the Toner, and the Stone leasehold estates. They were shallow wells. They were drilled to about 2,500 feet in a formation known as the Big Engine Formation in north central West Virginia. They were not Marcellus shale wells. They were not what we would call deep shallow wells. They were thousands of feet from that mineral formation. There are a number of undisputed items in this record. I'm going to briefly walk the court through them. It's undisputed that MFP's predecessor in title was part of a team that raised money and sold these fractured interest in oil and gas wells in north central West Virginia. Some of the shares remain outstanding to this day. It's undisputed that the assets that were produced and acquired were the Hudson acreage, which totals 490 mineral leasehold acres, the Towner acreage, which totals 34 acres, and the Stone acreage, which totals 97 mineral acres in north central West Virginia. And it's undisputed that these assets have been held by production from these drilling programs in the 1960s to present. And there are also some critical undisputed elements for the court. It's undisputed that in 1996, the day of the assignment, which brings us here this morning, MFP's direct predecessor had acquired and placed of record overriding royalty interest in Daughters County, West Virginia, and these were fully disclosed to Key Oil, the assignee within the 1996 assignment agreement, which brings us here this morning. MFP's predecessor disclosed a 1/16 override in the entirety.
Can I, counsel, sorry, I imagine my colleagues have too. We've read the briefs. Can you actually get to the question of why you think the 1996 assignment did not include all of James Drilling's interests? The district court said all means all. I understand you to say all means everything included in Exhibit A.
Semi-agree with that statement. So
okay, well, yeah, you have the paragraph 2 argument. You're happy to make that one, but at least focus on this second part.
Certainly.
I understand the paragraph 2 argument as well, but how about just focus on this piece? Why do you think, particularly described in Exhibit A, is a limitation on the word all?
Yes, certainly, Judge Richardson. If you look within Exhibit A, which is incorporated within the body of the 1996 assignment agreement, it's plainly binding on successors and assign. And Exhibit A is a very specific description of wells and interest. If we go to the document itself, you have to break the language down piece by piece, like a math equation. For example, on the Hudson interest, Exhibit A has a footnote which is binding within the document, and it describes specific parts of the oil and gas leasehold estates which are conveyed. That's in the notes section within Exhibit A. And those parts are all that certain 40-acre portion, limiting language, 40 acres, limiting language, upon which a well was drilled. And we've given the court the depths of the wells in 1996 that they were shallow. Thus, these are limited assignments or conveyances by the express terms of the 1996 assignment agreement.
All right, so I understand the first part of your argument is that Exhibit A limits what's transferred. I don't understand the second part of that, which is that I ought to read paragraph 1 to not refer to the entire 40-acre provision there, but instead only a part of that 40-acre provision.
Certainly.
Help me understand how I make that move. Why is upon which a well known was drilled, why that is a limitation rather than a description?
It's a limitation because in 1996, these wells had specific depths. And if you look further below in Exhibit A.
So that doesn't really like help me a whole lot, right? Because I'm trying to read paragraph 1 and I don't read the language to limit the 40-acre portion to the well that was drilled on it.
Okay, well, the language.
So help me understand that first piece. I understand you have a separate argument that paragraph 6 does something for you, but can you just help me with like paragraph 1? That is a particular 40-acre portion, and there seems to be part of your argument is that, well, no, it's not the whole 40-acre portion that's described in paragraph 1. It's really only this Hudson well number 1. Help me understand from an English perspective why I would read paragraph 1 that way.
Sure, and it's a borehole assignment, it's all it is, and it ties into the body of the assignment as well.
Okay, but when you say a borehole assignment, I understand that's your lingo, but what I don't see is how I don't see borehole assignment in paragraph 1. I don't see any reference to boreholes, right? What I see is a description of a 40-acre chunk. Upon
which a well was drilled.
Yeah.
And that
right?
is a...
That, also say, upon which the big white house stands, right? Or upon which, you know, the biggest pecan tree in the county sits, right? Okay, that's like a helpful description to understand which 40-acre portion we're referring to, but why is that a limitation?
Yeah, Judge Richardson, I agree with you. And if the document said upon which the White House sits plus or minus 1,000 feet, which is what this assignment agreement says in Exhibit A, within 1,000 feet of any presently existing well upon either of the aforesaid leases is what the assignment says further down in the body. And I think that's what the court is missing. You drill a well was drilled plus 1,000 feet. It's a buffer concept. It's a borehole plus a buffer of 1,000 feet up, down, sideways, and no matter how you construe that 1,000 feet, Antero, the respondents, lose this argument because the Marcellus Shale formation sits approximately 4,000 feet below the wells as they were drilled in 1996. Page 10 of our reply brief addresses this very specifically with a chart, which demonstrates how this 1996 limited assignment operates. And I don't want to stray from the court's question, but the court is reading Exhibit A without reference to the body, and the document must be construed as a whole. If we start in the preface, there are 3 except as hereinafter provided. That's limiting language, which you couple with the limitations in Exhibit A.
Can I ask one more question and then I'll let my colleagues, sorry, I don't mean to monopolize, but if I disagree with you, and so if I read paragraph 1 through 5 as referring to the entirety of those 40 acres, are you making an argument that you also have this sort of separate 1/64th net profit interest on other pieces that were not transferred to Haught in 78? Or is your whole argument that we've got to read 1 through 5 only as to the well itself?
There's a separate and independent basis, a very clear basis for why these overrides remain valid. And that's because from 1941 to present in West Virginia, and from the Bankers Pocahontas case, a covenant to pay royalties is a valid exception. The form of the exception is immaterial. Further, these profits and royalty interest were actually, it's not like we're dealing with inquiry notice, constructive notice. Key Oil in 1996 had actual knowledge of the existence of these royalty and profits interest, and they signed a contract as an assignee, which states in Section 2 that the assignee covenants and agrees to comply with the terms and conditions of the oil and gas leases in Exhibit A, including but not limited to payment of all net profits, payments, royalty, and overriding as defined in the leases. From our perspective, that language is crystalline, and that is what the district court failed to give any meaning to.
But that's the only, I just want to make sure, I think you have another argument, but I'm not sure you're making it. So I just want to make sure I understand. So again, to restate, if I disagree with what you've just said, right, that this is limited, that 1 through 5 is limited to the well, are you making any other argument such that if I said, no, it's not limited to the wells, that there's another piece of 1/64th net profit interest in portions of Hudson that were not transferred to Haught, that you actually were able to acquire? Is that part of your argument or not?
Our argument is that the Haught, you can take the Haught, our argument is that the Haught transaction isn't at issue here. Those are valid, they're in pay by Antero. The claims here relate to the entirety of the Hudson, the Towner, and the Stone lease, and that's what the language states. And that the entirety of this 1996 assignment agreement is limited in its very nature from the descriptions, and that's consistent with cases which have, may I finish? With cases that have previously been before this court and arguments which Antero has previously presented to this court in Mountaineer Minerals, which are all in the appendix record in this matter.
Judge Rushing, you have
Exceeded my time.
question? All right, thank you, counsel. Ms. Smith? Yep.
Thank you, Your Honor. My name is Amy Smith, and I'm here on behalf of the defendants and appellees in this action, Antero Resources Corporation, Key Oil Corporation, and Frank Butler. Your Honors, I'd like to step back just 1 second to what's really at issue here. Because one thing that Mr. Zimmerman never mentioned in his argument is the May 2008 assignment from James Drilling by which MFP claims its interests. Also, like the court to look, now that document is at JA 60. And at JA 60, that document only purports to assign a 1/64th of gross income override to, with regard to the 2 Hudson leases, the Towner lease and the Stone lease. There's no 1/32nd of Towner and Stone as alleged in the complaint, count 2. And there's no 1/64th net profits interest in the Hudson as alleged in count 2. And there's no 1/16th interest in by net profits interest in the Hudson leases, as is the place where Mr. Zimmerman started his argument before the court today. Count 2 of the second amended complaint, which is at JA 130, very clearly sets forth a claim, well, not very clearly, but it does attempt to set forth a claim of a 1/32nd interest in the Town and Stone or Towner and Stone leases, and a 1/64th net profits interest in the Hudson leases. Those references to book and page number in count 2 are references to prior assignments of those leases in 1960, long before any assignment was purported to go into MFP. Those are irrelevant, and MFP can claim no interest based on what its predecessors had. It's true he can only get what his predecessors had to give, but he doesn't get everything that someone had in 1960. Now, Mr. Zimmerman mentioned the 1/16th override in the Hudson lease. That was conveyed, that's at issue, by the way, Your Honors, count 1 of this case. This is an appeal based on a certification under Rule 54B of the district court's judgment with regard to count 2 and count 2 alone in this case. The 1/16th interest is at issue and currently being litigated in count 1. For some reason, the conclusion in Mr. Zimmerman's brief does request a declaration regarding the 1/16th interest. That's improper. It's not before the court in count 2. There's no question about that. The February 2008 assignment.
Counsel, can I ask you a version of the same question I asked your colleague? I understand that you likely agree with the district court that all in the 1996 agreement means all without limitation. But assume hypothetically for a minute that I disagreed with that. And I thought the 1996 agreement was limited to that which was included in Exhibit A. All right, just accept that as a hypothetical. I know you disagree with it, but accept it for a minute. And then accept that I read Exhibit A with respect to the Hudson lease to set forth 5 40-acre tracts in their entirety, as well as within 1,000 feet of existing wells, right? Which was basically the 78 transfer to Haught. If I agree, if that was the sort of legal conclusion, obviously that's different than what the district court concluded. Would there have been something left for the 2008 transfer? And in particular, what I'm thinking about is the portion that Hardbarger transferred to James Drilling in 1990. Is that 1/64th net profit interest in portions of the Hudson property? It's not all of it, but it's portions of it. Was that retained if I read the lease that way? Or does that, or do we not really know the answer to that because the district court just didn't get to that issue?
Your Honor, if I understand your question,
It's a hard one, I acknowledge.
I don't think that either the district court or the defendants would disagree with what I understood your reading to be of Exhibit A, because Exhibit A is limited, although to clarify, Exhibit A has the entire leasehold interest regarding those 40-acre tracts in the first 5 numbered paragraphs of the second page of Exhibit A. It's very clear from that that it says the specific parts of the oil and gas leasehold estates created by the oil and gas leases described in numbers 6 and 7 above, which is the Hudson leases. And it says, which are assigned by operation of the assignment agreement, are as follows. And Your Honor made a good point when it said, upon which a well known as CP Hudson well number 1, 2, 3, 4, that is merely descriptive. It's not limiting that conveyance to a wellbore assignment. It's only describing that there happens to be a well there. And with regard to number 6, that's not a depth limitation. That's an acknowledgement that in the interim, there may very well have been additional wells drilled. And with regard to those wells drilled, that they also, they being in this instance Key Oil, obtained all of the leasehold interests within 1,000 feet of any additional well. Because as Your Honor noted, this language started to come into the lease assignments way back in 1978 at least.
I mean, this is the exact language from the 78 Hawk transfer.
I believe you're right, Your Honor, yes.
And so 6 would encompass whatever wells have been drilled between 78 and 96.
Yes, Your Honor. It's additional wells. It's no indication of a well bore or depth limitation.
But so just help me maybe try to understand this. But when the Hawk transfer was made in 78, my understanding is this was what was included, but there were other things that were excluded from that transfer, right? And that was the portion that Hardbarger had. And that portion was then returned to James Drilling in 1990, which means James Drilling had it in 96, but it's not included on this list in Exhibit A.
Well, there are other interests in other leases, Your Honor, yes.
Yeah, but this is one in Hudson. It's a 1/64th net profit interest in Hudson, right? It went from Shearer to Hardbarger in 61, and then Hardbarger gave part of it to Rawlings in 64, and then he kept 1/64th, and he gave that to James Drilling, transferred to James Drilling in 1990.
And that is part of the conveyance because
Part of which conveyance? The 96 conveyance?
Yes, Your Honor, it's part of
Why? Tell me why. I don't understand that at all.
Oh, absolutely, Your Honor, because the recital and the granting clause in the 1996 conveyance to Key Oil very expressly grants all, let me see, it says all of their right, title, and interest in and to those certain oil and gas lease, and that would be one of those.
No. Okay, but it says, as more particularly described in Exhibit A. And we've just established that what the interest that I'm describing for, what I'll call Hardbarger's 164th, is not included in Exhibit A. It's not in 1, 2, 3, 4, or 5, or 6.
Your
That's
Honor,
describing the Hudson lease.
Your Honor, those are references to the original lease, and all portions of the original lease were in James Drilling in 1990. That is something that's been agreed to by the parties, and the court noted it, the district court noted it in its opinion. Yes, the references to the Hudson leases in the first page of Exhibit A are general references to the original lease and the date of the lease, and those 164 net profit interests were conveyed back to James Drilling in 1990, and they did go to E Oil in 1996.
But just help me real quick, and I'll then stop. But do you agree that it's not included in the 6 numbered paragraphs of the 1996 agreement? That 164th interest that Hardbarger had, that James Drilling got in 1990, it's not included in those 6 paragraphs, right?
Right. All of the interests are included in those 6 paragraphs, meaning, and this goes, I think, to...
Why is that? We have 5 40-acre parcels. I'm not a math major, but that doesn't equal all of the Hudson lease, right?
Okay.
The Hudson lease is 490 maybe, right?
Yes.
And so we've identified 200 of 490. I understand that to be 200 to be less than 490.
But within the 200, the 164th net profits interest is included. Outside, and that's the only portion. So when in the assignment to Key Oil in 1996, it's not the 400 or so acres of the 2 Hudson leases, it's this acreage. But within the acreage that is described in Exhibit A, all of James Drilling's interests and Shear's interests were conveyed to Key Oil. And that includes all of the working interests, the overriding interest, profit interest. What I believe the disconnect is here is that there is residue, the other 200 or so acres of the Hudson leases that's not part of the conveyance to Key Oil and is not at issue in count 2.
Ms. Smith, maybe since on this subject here, and this is an inquiry, help me with this. In JA 54243, it seems like it suggested there's a limitation about your expectations of profits, and it seems like it's almost acknowledging something you may not have purchased. Can you help me with those 2 pages of the JA? It's an informal document. It's not, you know what I'm saying, but it's, and I don't know, it may just suggest it, but can you help me with that? It's in 543, 542, 543.
Yes, Your Honor. I'm looking at those pages now, and I believe, what that indicates is that there is an override in James Drilling that would be assigned by virtue of assignment of all of James Drilling's interests. It looks like there's also an outstanding override. That could be an override in a third party, which goes to paragraph number 2 that was not really addressed in full, perhaps, in Mr. Zimmerman's argument, but really the only argument regarding any limitation of the transfer of the overrides that Mr. Zimmerman has is by virtue of misconstruing the terms and conditions in paragraph 2 of the terms and conditions of the 1996 leasehold assignment into Key Oil. That numbered paragraph 2 indicates that Key Oil agrees that it will pay net profits payments, royalty, and overriding royalty as defined in the leases or any assignments heretofore disclosed to assignee. That is third-party overriding royalty. Mr. Zimmerman said that the court did not address that. In fact, the district court did address it, and the district court agreed with that reading of it, that it's a third-party royalty override net profits interest that Key Oil agreed to pay. And there are, in fact, the court identified, there are some of those extra third-party overriding royalties or any other types of interest that make that paragraph not superfluous. And so that's what that means. This is simply a working paper, Your Honor, that was produced by Key Oil in discovery. Honestly, no one was deposed about what these working papers from their due diligence actually mean. But Mr. Zimmerman makes the point that Key Oil knew about the overrides. Of course, Key Oil knew about the overrides held by James Drilling. They were transferred to Key Oil. When all means all in the granting clause, all of its right, title, and interest to these leasehold estates, that includes the working interest, the overriding royalty interest, the net profit interest, all of the interests held by James Drilling at the time of the transfer, which the parties have agreed and the court has agreed below, include all of these interests possibly claimed by MFP, even though MFP keeps changing its mind about what these interests are. Now, the other thing that I'd like to address, Mr. Zimmerman pointed to the Mountaineer Minerals case. The language, the granting language in the Mountaineer Minerals case is clearly distinguishable from the granting language involved in this case. In the Mountaineer Mineral case, the grant was in and to the following oil and or gas wells and any and all leasehold rights associated therewith. Your Honor, Judge Gregory, I believe you were on the panel in Mountaineer Minerals that held that that was a wellbore assignment. That's not what we have here. What we have here, Your Honor, is like the Blackshear lease in the TransEnergy versus EQT production case, which is 743 F3rd 895. That's a Fourth Circuit case where I believe, Judge Gregory, you wrote the opinion in 2014. And in that case, it involved the Blackshear lease. And there was an argument made that the Blackshear lease was limited to oil because a list of wells, one of them was an oil well. The court held no, this was an assignment of both leases and wells, and it was not limited to oil, it was all interest. That's what this case is. And may I continue?
Yes, you may.
And the judgment of the district court that held that MFP could not establish even the first element of a breach of contract claim because it did not own the interest that it claims in the Toner, Stone, and Hudson leases, alleged in count 2. It doesn't own them. It can't establish a breach of contract. Thank you, Your Honor.
Thank you, counsel. Mrs. Simon, you have some time reserved.
Yes, Judge. I believe it's 7 minutes left.
Yeah, 7.
Yeah, Ms. Smith and I can certainly agree upon something. The word all does mean all. And in paragraph 2, the word all has to mean all. It doesn't say third party overriding royalties, third party net profit interest. It says all royalty, revenue, profits, interest. The foundation for part of Antero's argument is contrary to the record in this case. The McCardle family partnership was assigned the 16th in the Hot, as well as the other 16th, 32nd, 64th, and 16th in all the Hudson. There are 2 assignments in this record, not one as suggested by Antero. Book 222, page 393, Book 222, page 395. One is a conveyance of the 16th outside of the 40. The other is a 16th in all of the Hudson. That's in the record. Antero's argument on that point falls flat. I want to briefly discuss Mountaineer Minerals. It was argued.
Can I just ask you, you brought this up and I can't figure out what this is really talking about. In the 222392 assignment, on the second page of it, the second paragraph, the second sentence, it says the aforesaid leases, referring to the 2 Hudson leases, lack the overriding royalty to 5 40-acre tracts or parcels which were assigned in previous assignments.
Correct. And then if you look at,
And those are the 5 40-acre parcels that are listed in the 1996 assignment, paragraphs 1, 2, 3, 4, and 5.
correct. That's
Okay.
correct. And then there's a separate assignment in this record at 222395, which is an assignment of all the overriding royalty interest in the Hudson, Towner, and Stone acreage in the 490, the 97, and the 34. So there are 2 assignments into McCardle Family Partnership. He's clearly.
But the point is, in the February 2008, there's a recognition that there's, in the Hudson, James Drilling has these 5 40-acre pieces, and then it has a remainder, right? Some acres, 290-ish, maybe, I don't know, some number like that, that it also has an interest in. And that's what the February 2008 lease sort of is acknowledging.
The 2 assignments acknowledge the title split, that the overrides on one side went on this side and the overrides went on the other side. And what Mr. McCardle was doing was cleaning up the files, and he then merged both of them into the McCardle Family Partnership because he had to, based on how the title was severed. So he made a full circle there in terms of the 64th, the 16th, the 32nd in all of the acreage. So the record is clear there. I'd like to turn briefly to Mountaineer Minerals. It was up to the 4th Circuit, May 29th, 2019 opinion, back down September 12th, 2019, Northern District of West Virginia on remand. And in that case, Antero argued that all the indications and all of the limitations in the 1996 assignment today were in fact limiting language. And Judge Stamp relied upon the same indicia, the same evidence to conclude that a 1996 assignment agreement in West Virginia involving Antero and Key Oil was in fact a limited assignment. And the court looked at, like we have in our 1996 assignment, the fact the plugging liability went to the assignee, the fact that the pump jack, there were references to well materials and well equipment, went to the assignee. And the court also looked at the royalty covenant in that case to determine that it was a limited wellbore assignment, and that's all reflected in Mountaineer Minerals. It's a Northern District of West Virginia 116 CV 228 decision on pages 9, 12, 15, and 16. This case isn't anything like the TransEnergy case. To address that point, the TransEnergy exhibit was not limited in any way, shape, or form. The way I read that opinion, there was a box where there was a check for oil or gas, and that's what the court looked at. Here, We have limiting language on the face of the assignment which was not given any consideration by the district court in its opinion. And all does mean all. I haven't really touched on merger, and that's intentional because the court didn't make any real findings at the district court level about the doctrine of merger. I do want to talk briefly about one case cited in our brief. It's the Page decision. It's a Colorado case, and it really evidences what Antero and Key are trying to do here. They're trying to receive the benefit or benefits of the 1996 assignment agreement and shirk the burdens so that they can maximize their revenue interest in this production and not pay the McCardle family partnership based on the clarity of the 1996 assignment agreement. What they're trying to do is to expand their interest in the wells by cutting out the McCardle family partnership and its clearly of record overriding royalty interest in the entirety of the Hudson, the Towner, and the Stone acreage. Now, I think the court, Judge Richardson, asked a question earlier, which I think deserves some comment. The Hudson reservation or exception of the deep rights, it's more specific than the Towner and the Stone because of the as-drilled limitations, the 1,000-foot limitation, and the note that all that was conveyed in 1996 as to Hudson were specific parts of the oil and gas leasehold estate, which are assigned as follows: a portion, as drilled, not the entirety of the state. It never touched the Marcellus Shale in 1996, and this transaction reflects that. And it's not just one place that talks about payment of royalties, net profits, and revenue. It's multiple places in the assignments. In paragraph 2, it's in paragraph 4, and it was agreed and understood that these were to run with the land. That's what the document says. And Key Oil knew that all meant all. The assignee included that language in this document in 1996. We respectfully submit the district court erred and the opinion should be reversed. The language should be given a fair reading. And I've overrun my time. My shot clock's up.
I thank both counsel, and we appreciate your arguments, and we'll have
And if we can have the attorneys for the second case, please unmute and show your cameras. Thank you.
Very good. Sorry about that.
Not a problem.
all right. Ms. Wall?
Yes, thank you, Your Honor. May it please the court, my name is Melissa Wall, and I represent the appellants, C.D. and his mother, Indy. We are asking this panel to reverse the decision of the district court and to remand for further consideration of the procedural and substantive denials of faith identified in our briefs. This case involves a high school student who was not properly identified nor provided a faith, in other words, a free and appropriate public education, and because of these failures was substantively harmed. While there are 4 important points of error raised in our briefs, I ask this court to focus on 2 particularly troublesome issues: equitable estoppel and reliance on the student's grades and graduation from high school. First, the district court abused its discretion and committed an error of law by applying equitable estoppel to bar the parent's timely filed claims, which denied them their rights under the IDEA. In this remedial statute, Congress gave parents the right to file claims within 2 years of the date they knew or should have known about the alleged action forming the basis of their complaint. Applying equitable estoppel to reject claims that indisputably were filed by CD and ND within the 2-year statute of limitations judicially overrides the plain meaning and statutory purpose of this remedial statute. Applying common theories for statutory interpretation, the district court's application of equitable estoppel to IDEA claims must fail. Under textualism, Congress very clearly gives parties 2 years to file. In addition, Congress identified only one situation where a consequence could be imposed on a parent for failing to dissent to an IEP within a certain time period. This is in the context of a parent seeking tuition reimbursement. We call it the 10-day notice rule. Notably, all cases cited by the district court to support its use of equitable estoppel are tuition reimbursement cases. Our case is not. Because Congress identified this one scenario and no other, it is legal error to impose additional consequences, such as barring the parent's claims if a parent consents to or fails to dissent to a school decision. Under the theory of intentionalism, Congress intended this remedial statute to provide parents with relief when schools fail to provide their child a FAPE. Applying equitable estoppel short-circuits this congressionally intended right to obtain relief. And under the theory of pragmatism, to accept the district court's application of equitable estoppel in IDEA cases would turn certainty into chaos. In all but the Eastern District of Virginia, parents and schools can rely on the fact that parties have 2 years within which to bring claims. In applying equitable estoppel to IDEA claims, the hearing officer in the district court were quite nebulous on when exactly it is the parent is supposed to voice this dissent. Is it 6 weeks? 6 months? 1 year? This vague application of equitable estoppel will not only confuse parents, but it injects chaos into an area of special education law that has been firmly settled for decades. Additionally,
Can I ask you a question?
yes, sure.
Even if it doesn't rise to the level of estoppel, do you agree that it's relevant whether a parent agrees with the school system that no reassessment is necessary? Looks like the Department of Education has said when conducting a reevaluation, the school should consult with the parent, and if the parent wants a new assessment, it should be done, but if not, the school can proceed on the data it already has. So that wouldn't stop a parent, but that seems to suggest that if the parent doesn't request a reassessment, then the school can proceed on the data it already holds. So in that sense, the parent's consent is relevant, doesn't stop them from bringing a claim 2 years later, but do you agree that it's at least a relevant it's legally relevant whether the parents consented?
Yes, I do think that parent consent is a relevant point, but I think the bigger point is the equitable point that parents don't have the same level of expertise or access to information, and certainly not the same level of access to experts to be able to effectively make these decisions on the fly and immediately. It's the school district that has all of that information. And again, the parent's claim here is that the school district, based on the information it had and it reviewed on April 7th, 2021, did not see the red flags indicating that this child had deficits in writing skills and also in receptive language skills. So therefore, they did not assess the student in all areas of suspected disability. That's actually the basis of the parent's claim here. And so the fact that the parent gave consent, that is factually accurate, but the point is that the school district failed to identify and to assess all areas of suspected disability. The parent cannot be expected to have the same level of expertise or access to information or experts that the school does to immediately be able to assess whether the school district met that responsibility, that legal responsibility. It took time for results of this decision to play out for the parent to finally realize, hey, something was wrong here. And that's what Congress acknowledged when it chose to set in 2004 a 2-year statute of limitations period. Prior to that, states did all kinds of things, anywhere from a matter of months to 5 years for parents to file. But seeing how that played out in the various jurisdictions, Congress made an affirmative choice that 2 years was the right amount of time for parents to learn and discover the mistakes or the problems or the negative results from the decisions that a school made.
Right, in this case, follow up with Judge Rushing's question here in terms of relevance. And you're right, parents, it's certainly not an equal possession of knowledge about the subject, parents and schools, but here the parents did have persons with them. They didn't come alone, did they, early on in terms of, because you started saying that it was not properly identified. Did the parents ever object to the identification of the exceptional educational situation here?
So 2 points. First of all, the parent did not have an advocate or attorney with her on April 7th, 2021 in this eligibility and IEP meeting. The advocate that she had was in 2018. And the second question that you raised about, did she agree with the findings? Actually, no, she didn't agree with the findings. She provided consent to a change in eligibility. And in fact, the parent has never contested that the student does not have specific learning disabilities in reading and math or other health impairment, ADHD. That's never been the parent's position. The student does in fact have those disabilities, and that was confirmed in the IDE.
I didn't think so either, but you started off saying that it was not properly identified. You said the problem was not properly identified. And what is the problem you're saying that wasn't identified?
So what the school missed were red flags in the documents and the information they had on April 7, 2021, that this student also had a specific learning disability in writing, that this student also had a disability in his receptive language. And then we ultimately found later it was both expressive and receptive language. But the evidence that the team reviewed that day, April 7, 2021, which included the 2018 evaluations, which showed that the student had deficits in receptive language. That's what they reviewed that day. Those were the red flags, and they failed to adequately assess to identify whether these suspected disabilities were in fact in place. And they ultimately, what we now know, were missed.
Can I ask this, maybe I'm not following it exactly, but your suggestion is that the red flag should have been so obvious to the school, and yet those same red flags would have been impossible for a parent to understand, right? I'm having a little trouble sort of like balancing those two, that, you know, something has to be obvious in order for it to be a problem for the school, and yet you're sort of contrasting that by saying, but of course no parent could possibly understand that their kid couldn't read and write. Can you help me understand how to play that tension?
Yes, absolutely. Our parent was an FBI agent for 21 years and now works in the DEA in the compliance department. Her area of expertise is criminal law. She is not an expert in special education law. She is not an expert in speech language disabilities. She is not an expert in specific learning disabilities. That is not expertise she possesses. However, that is exactly the expertise that a school district possesses. And I think
Didn't the hearing officer address this? I mean, I thought the hearing officer found the school experts, the folks who worked with the student, more persuasive than the parent's expert in understanding what the school should have recognized in April 2021. And the hearing officer found the school more persuasive and credited that no one there, including the parent, but also the folks who have expertise in this area, should have seen or would have seen that this, at that time, was an area of deficit that warranted special education. And we have a pretty high deferential standard that we apply to those findings. So how do you overcome that?
So the issue here is that the responsibility for identifying all areas of suspected disability very clearly was placed on the school district, not the parent. So first of all, it's the school district's responsibility. And this is where the legal error comes in, is exactly what does it mean to suspect a disability? The Ninth Circuit, which we cited in our briefs, said it's a pretty low bar. I mean, if there's a reasonable belief that this could happen, the school district can't just rely on observations of their staff or their impressions, right? There was actually hard data in the record that showed not only the 2018 testing that showed the receptive language deficits, but the fact the student had failed his writing SOL. The fact that the teacher at that meeting in April 2021 said he had deficits in his writing skills. How much evidence should be in the record to determine whether or not there's a suspicion? Is it beyond a reasonable doubt? And our position is no. And that's where we feel the legal error came in. It's not about who had most credibility. In fact, the hearing officer found all of the expert witnesses credible. He just gave more weight to one than the other. But the problem is, what does it mean to suspect a disability? And that's what we're asking this court to address.
Can I ask you a question about the hearing? It looks like the parent requested that the hearing be open to the public. Is that right?
Yes.
Why is the hearing transcript and most of the joint appendix under seal if the hearing was open to the public, which included the student's name, parent's name, the school's name, all the disability information? Why is that under seal on appeal?
That was simple because normally, especially in these videotaped hearings, where it's very controlled who actually gets in to this video conference, we try to leave the door open though if there are law students or other advocates or professionals who are trying to gain experience in observing these hearings have that opportunity to do so. But there was no one from the public who was present, and in this case, there were actually no law students present either to observe, but it was merely to make that option available for educational purposes.
So are you telling me it was open to the public, but no one from the public attended, and we know that for certain because it was a video proceeding?
That's correct.
Thank you.
And I will note too that the parents sought sealing once the documents went into the public record in the public realm when the case was filed in district court to protect the confidentiality of the student. The second troublesome issue I wanted to make sure that we highlight is the school's reliance on, and the court's reliance on CD graduating from high school and getting mostly good grades. The purpose of the IDEA, as stated in the statute itself, is to prepare students for further education, employment, and independent living, not specifically to graduate. And the William A. case that we cited is a perfect example of this. The student graduated with 3.4 GPA and couldn't read. And the Sixth Circuit correctly decided a FAPE was not conferred to that student. And the school board noted at page 49 of its brief that the school provided William with accommodations that masked his inability to read. That is exactly what happened to CD. The school board gave CD a credit accommodation to actually be able to graduate. Why? Because he had failed his 8th, 11th, and 12th grade writing SOLs, which is clear evidence that CD graduated without the basic fundamental writing skills that the Virginia Department of Education has said our Virginia graduates should possess. He did not. And if the school had all along had goals or provided specially designed instruction to remediate his writing deficits, and yet he still couldn't pass, that's one thing. That's not what happened here. The school never identified his specific learning disability in writing. They never provided goals in his IEPs for writing, and they never provided him with specially designed instruction to remediate his writing deficits. Providing him that credit accommodation is the only way reason this kid graduated, and it was to mask the fact that the school board
He was
failed.
headed to community college, right? He graduated with A's and B's, and was headed to community college. Isn't that different than a case when a student can't read or write, yet somehow graduated?
So he didn't graduate with all A's and B's. He had some bad grades. And if you look behind the grades, for example, history, he got a, is it okay if I continue to answer?
Yes, go ahead, yes.
Thank you.
You may.
In history, he got a C in that class, but when you actually go back and look at the scores, which is briefed in it already for the court, the specifics of that, he failed all of his tests and quizzes for almost the entire school year. Clearly, he didn't know or understand that history. And interestingly, when he went to community college, he failed 2 of his 5 classes that first semester. One was math, where he had failed in high school, and the other was history. So clearly, there has been an impact on the student in his further education because he's struggling so much in community college. In the last 2.5 years, he's either failed or had to withdraw from many of his community college classes. So clearly, the IDA purpose of preparing him for further education did not happen here.
Can you tell us about, didn't the school recommend that he go to summer school?
That was in order for him to repeat one of his math classes so he could remain on track to get an advanced diploma. I mean, keep in mind, this is a smart kid who had high average to superior intelligence. He had the cognitive ability to learn how to write. He had the cognitive ability to learn how to read on grade level, but that didn't happen.
But he didn't go to summer school, right?
You didn't answer the question. You didn't send him to summer school. I mean, your client didn't.
Yes, he did not attend summer school to retake that class.
And that was against the recommendation of the school, correct? Is that right, counsel?
It was an option for him to be able to do that if he wanted to stay on the advanced diploma track. And
You're not answering my question. It was the decision of the not to go to summer school. That was against the recommendation of the school.
It is factually correct that the student did not attend summer school.
And the parents chose this not send him, is that right? Who made that decision?
I don't know factually if it was specifically the student or the parent, but ultimately the parent's responsible. So responsibility, I think, lies with the parent.
All right, any other questions? All right, thank you, Ms. Wall. Mr. Cafferty.
Very good, members of the panel. Thank you. I'm John Cafferty for the Appalachee Arlington County School Board in this case. In this case, the administrative hearing officer heard a lengthy amount of testimony, considered a number of exhibits, made a highly detailed report of his findings concerning really all these factual issues, including express findings of credibility. And the district court, as you can see from Judge Brinkema's opinion, reviewed that record carefully, both his findings, but also the record that went behind it, and determined that they were regularly made and that the hearing officer had gotten it right. Those findings, under the clear jurisprudence of this court, from the Doyle case in the early 90s to the GM case just decided a year or so ago, make it clear that those findings are entitled to due weight. They're entitled to be considered prima facie correct. We submit that they are correct. One thing that I want to say up front here, because there was some discussion of this, is, and this is important, this is not a case, members of the panel, this is not a case where a student was improperly graduated, was pushed through, and graduates from high school, and then you find out the student can't read or write. Nobody says that. The appellant doesn't say that. The teachers who testified certainly didn't say that. And it's not just in fact, the teachers talked and counsel, Ms. Waugh, called almost every teacher the student had for the last 2 years, and they talked about what it meant to earn a grade of A or B or whatever. And these are regular curriculum classes. These are not separate centers. These are the same, English and math and social studies classes that regular high school students were taking all the way through the student's tenure in high school. But if you look, for example, at Joint Appendix 261, that's the standards of learning examination that students have to take. Student got a 440 on that, a passing score, more than a passing score in reading. Judge Brinkema talks about the fact that he got an A in English. If you look at the Joint Appendix 273 and also 473, excuse me, you'll see that the student had to pass or get credit for, it isn't just a matter that the student got good grades, but there are standards of learning examinations you have to pass to make sure you don't get out of high school and without being able to read or write. The student absolutely did that, matriculated to college, and so just in terms of a reality check, we're not talking about one of these cases where a student gets out of school and can't read or write. I do want to talk about the estoppel point relative to the much of the hearing and the briefing and the lawsuit had to do with this claim that the April 7th, 2021 eligibility committee or evaluation was somehow inadequate. Now, the estoppel holding, I want to be clear, that's just an alternative holding because both the hearing officer and the district court went on to find that substantively on the merits, the evaluation was appropriate and adequately complete anyway. But I do want to come back to the estoppel holding. Estoppel in IDEA cases is something that is suggested, but I would warrant is not expressly discussed in the jurisprudence of this court. Want to make a couple points that I think are important. One is that the IDEA, the scheme that's envisioned by the IDEA is not a unilateral scheme where the school system makes a decision on eligibility, the school system makes a decision on IEP and hands it to a parent. In fact, Judge Rushing, in the GM case you talk about this. It's a cooperative scheme. It's a cooperative scheme between the school system and parents. It's a cooperative process. They work together to identify a student. They work together to identify, develop a plan. And then both parties, we submit, own the result of that plan. And then there's a provision that your IEPs have to be revisited at least yearly. Eligibility has to be revisited at least every 3 years. And so it's a cooperative process and really important in that scheme is that parents have important rights that admittedly the parent was aware of here. She wasn't a special education lawyer, but she certainly was an attorney. She had used, at least in the past, educational advocates. Judge Brinkema points that out in one of her footnotes. She knew that was a thing. But there are 4 important procedural rights. And Judge Gregory, I hear your observation there, but the parents do have, it's not by any means a one-way street. Parents, and importantly in Virginia, parents have the right to consent or not consent. And Virginia is in a minority of states. In most states, the school system proposes an IEP and proposes eligibility, and then they send a notice to parents, and then it's up to parents to request a hearing or mediation if they don't like the result. Virginia is one of, I think, 5 states. The site, by the way, I think it's in our papers, but it's 8 VAC 20-81-170E, where you have to get affirmative parent consent to make a change in eligibility or a change in IEP. And so the parent here, it isn't just that so some of these cases that deal with, well, a parent didn't object to the IEP or a parent didn't object to the eligibility. Importantly, look at Joint Appendix 1628. That was my cross-examination of mom, where she says not just that she didn't object, but she agreed. She affirmatively agreed to the eligibility determination in April of 2021. She also agreed, by the way, to the next IEPs that were based on the succeeding IEPs that were based on that eligibility. So parents, maybe it's not a completely level playing field, but there are a number of things, and frankly, this resonates back to the discussion of Justice O'Connor in the 2005 Schaefer versus Wiest case. That's a case that went up and down, and the Judge Wilkinson's decision is a later version of the same thing. But in 2005, the U.S. Supreme Court was looking at the question of who should we put the burden of proof on? And Justice O'Connor says, well, there are a number of procedural rights the parent have. I mean, consent I've talked about is one of them. Parents also have the right to inspect their child's educational records. Importantly, they also have the right to get what's called an independent educational evaluation, so that mom, if she had some question about the 2021 eligibility, she had the right to go out and get her own outside evaluations. She knew that. She didn't do that. And then, frankly, there are a number of dispute resolution mechanisms. Due process hearing is one, mediation is another. But so I don't. It's not. We would submit inequitable. And again, we're talking here not about a bright line rule or a matter of law rule. As Judge Wilkinson says in the 2009 Fourth Circuit Schaefer versus Wiest, we're talking about matters of degree. But does it matter that parent was aware of her rights, affirmatively agreed, allowed 2 IEPs to be prepared on the basis of this, and then didn't voice any objection to it? We submit that under that universe of facts that were considered both by the hearing officer and Judge Brinkema, that was relevant, and that could permissibly be the basis for, as Judge Wilkinson says, and we certainly quoted it a number of times in our papers, Monday morning quarterback that decision. We submit that all the elements of estoppel are there, not just latches, estoppel, affirmative representation. Yes, I agree to that. And Judge Brinkema sets this out in her decision better than I can, but taking a position, yes, I agree with this evaluation, a different position, no, I don't agree with this, and then the school system acting in reliance on that in the meantime, that was a permissible basis for a ruling on the eligibility point. By the way, it has nothing to do. There's a lot of discussion in the appellant's papers about, well, we're not barred by the statute of limitations. No, the claim was filed literally on the last day of the limitations period, but we're not saying that challenge to the April 7th, 2021 of eligibility determination was barred by the limitations period, but it's a bit like saying, well, yes, you're within your limitations period, but you're foreclosed on the basis of some other defense, whether it's agreement or a waiver, could be a lot of reasons. But as far as
Counsel
makes the point, well, this is
Counsel, may I ask a question?
Oh, sure. I'm sorry.
No, that's fine. Do you agree that everything you were just talking about is also relevant to the substance of the school's decision, whether anyone knew at the time that there was something they were overlooking? If we perhaps have trouble getting our heads around the limits of this estoppel argument and who it would apply to and who it wouldn't, that your argument still applies to the merits?
Yes, Your Honor, absolutely. And I think both the hearing officer and Judge Brinkema said as much. It's clear, as Your Honor has already said, that under the prevailing regulations, there can be situations where a whole new raft of evaluations is not required. It was permissible, as the team factually did, to look at other things, grades, IEP progress reports. And I want to make sure that the panel is clear. Those are two very different things. Grades are just the kind of report card that we're used to. IEP progress reports, which are also in the evidence, are the special education teachers look at how is the student coming on their IEP goals? So you have that, you have other testing, SOL testing, Lexile testing. I've talked some about that. And then you had what the teachers themselves were saying. So yes, that's, that's why I said it was an alternative holding. Ultimately the hearing officer and the district judge in a sort of a belt and suspenders approach said, if you actually look at the merits of that, they got that right. That is a factual finding, questions of appropriateness under RF versus Cecil County Public Schools and other cases. Those questions about whether something was appropriate or not, that's a factual finding that's entitled to deference under Doyle and GM and many cases. And as Your Honor pointed out, the hearing officer didn't just make sort of a bare factual finding, but explained, I heard what the private psychologist had to say, and I found it less compelling than the school psychologist. The school psychologist, he gives a number of reasons, but yes, to answer a long way of answering your question, we submit that all those things bear on the substance of it. And then the final point, just coming back, Judge Gregory, to something you said at the beginning is, at the end of the day, they don't disagree with the disability classification anyway. It is specific learning disability and other health impaired. And so there was no disagreement on that at all. I want to move on briefly to talk about the appropriateness of the IEPs and the appropriateness of the education that the student received. And I just have to disagree with counsel. It's true that matriculation through grades and passing grades, and this student mostly achieved better than passing grades, took things like physics and honors, this and that. It may not be everything, but it's pretty doggone important. And the court said that, and the Supreme Court said that in the Rowley case. The Supreme Court said that again in the Andrew case. And there's no getting around the fact that the student validly graduated again with a regular diploma. IDEA doesn't require you to get, in order to meet that threshold standard of appropriateness, educational benefit, that you get an advanced diploma or that you get on the honor roll. And counsel in her remarks talks about, well, he got a C in math and he could have done better, or even frankly a D. In terms of both, the grades are important, but again, the IEP team didn't rely just on grades. SOLs, Lexiles, and things of that nature. And we would submit that the criticisms are really just better versus appropriate type of things. Here's one more thing. And this comes back to something the court said, the Fourth Circuit said in the 2015 OS case, which is, counsel's approach here was primarily on the appropriateness point, and really most of the hearing, as both the hearing officer and Judge Brinkema pointed out, was spent on these procedural issues. But there was expert testimony from special educators in support of the position that the school system's proposal was appropriate. Not so in the case of the parents' case. The Fourth Circuit in the OS case said it's hard to, may not be impossible, but it's awfully hard to win your substantive appropriateness case in that situation. Let me move on just briefly to the, let's see. Oh, there's an issue of timing of the evaluations, and really because it's true, there was an evaluation requested in mid-December. The thing I wanted to point out, which is kind of a factual point, but it's the basis on which the factual finding was of essentially no deprivation of FAPE was made, and that is this. Even if the school system had proceeded with evaluation starting in December 15th of 2022, if you look at the clock, or if you look at the calendar, it would have been about April 22nd 2023, about 5 weeks before the substantive classwork ended, because they say classes ended on June the 9th, but really the last week was just a winding up. So that's more like June the 2nd. That's only about 5 weeks. And it was permissible for the hearing officer and the district court to say that's, even if we had evaluations, it wouldn't have really, there wouldn't have been time for it to really make any difference. But in any event, Judge Brinkema describes the contrary point as being vastly overstated. It was up to the hearing officer and the district court to determine whether something had a substantive effect. That's what they did, and they determined that it had not. I honestly, I think those are the points that I wanted to make. I hate not to use all my time, but if members of the panel have other questions, I'm glad to entertain them. Otherwise, I do thank you for your attention.
Mr. Cafferty.
Thank you.
Well, you have the time reserved. Wow.
Thank you, Your Honors. So just a few points I want to make based on Mr. Cafferty's statements here today. While it's true that deference is given to factual findings and credibility findings of a hearing officer that are regularly made, it's important to note that deference is not a rubber stamp. And there are examples where this Fourth Circuit Court of Appeals have found that decisions made by a hearing officer were not actually in truth supported by the record. Mr. Cafferty also stated that a difference between this case and the William F. case is that this student can read and write. However, the factual record will dispute that, because the student, again, failed his 8th, 11th, and 12th grade writing SOLs, which meant he did not meet the bare minimum standard to be able to graduate from high school with appropriate writing skills. And Dr. Henley and Ms. Sarami, the parents' expert witnesses, testified that his mixed expressive receptive language disorder would affect his reading and writing skills. Mr. Cafferty rightly pointed out that—
So can I just clarify exactly what you're saying? Because it sounded like you first said the record will refute that he can read and write. But then you said maybe he just didn't have the skills he needed to graduate 12th grade with, a certain amount of writing skills. Are you saying this student cannot read or write at all?
No, I am not. What
Okay.
I'm saying is that we haven't even really discussed the reading. He was below grade level. That's factually in the record when he graduated. But the writing is what I was referring to, that he did not have the requisite minimum level of writing skills that the Virginia Department of Education said we expect of our Virginia high school graduates.
Okay, so that's the argument, not that he cannot write. I just want to make sure I understand what you're claiming the record represents. So you're claiming the record represents he didn't pass the standard of learning for the 12th grade for graduation and writing. Is that right?
Yeah, 8th, 11th, and 12th grade.
Thanks.
So it wasn't a one-off. Also about this cooperative process, if this court were to hold that it's just fine to apply equitable estoppel principles, this cooperative process intended by the IDEA is going to be blown up. Because if it becomes the law of our land that if a parent provides consent to an IEP at that IEP meeting or shortly thereafter, they have now waived for all time their right to raise claims, that now incentivizes parents to keep fighting for a perfect IEP at the detriment of the good, which is actually getting services to the student as quickly as possible. The public policy consequences of this are devastating and completely contradict the intent and purposes of the IDEA. And I want to point out, how was the school board harmed here for equitable estoppel? Because there has to be a harm, some kind of detriment to the school. Mr. Cafferty said that the school relied on the parents' consent in creating these IEPs over time. I would argue that what the IDEA foresees is that schools aren't relying on parents' consent. Schools are relying on the data, the testing, the teacher observations, maybe grades, maybe SOL scores. This is what the school board relies on to develop an IEP. Whether the parent has given consent or not given consent is irrelevant. That has nothing to do with what information a school needs to develop an appropriate IEP.
I mean, that's a pretty strong statement. I just hate to let that go. Like,
Right.
what a parent thinks is irrelevant to his child's education? That's
No.
like a remarkable statement. I mean, I understand maybe that's your position, but that seems to be just a remarkable statement.
May I respond?
Yes, you may.
That is not my position. My statement was that the school is not relying on the parent's consent when it develops an IEP. That's not what's relevant. Certainly, the parent's comments in an IEP meeting or an eligibility meeting are relevant, a student's comments, but also actual data such as SOL scores, grades, the observations of the teachers in the classroom. All of this is important information that a school uses to develop an IEP. Whether the parent agrees to whatever the IEP is that's being proposed, and keep in mind, the parent is giving consent to implement the IEP. The federal regulations, the Virginia regulations, all differentiate between consent and agree. These are not the same thing. But the parent is consenting to implementing the IEP. That doesn't necessarily mean they agree with everything that is in that IEP or how the school made those decisions. In fact, oftentimes, and as the parent did testify, it's in the record, the parent believes if they don't give consent, their child will get no services at all. And frankly, some services are better than no services. So again, the fact that a parent consents to an IEP or eligibility decision, that's not what the school is using to develop an IEP over time, and it shouldn't be. It's the actual evidence in the record. It's the actual progress reports and things that they're relying on to develop that. So again, where's the harm to the school by the parent actually taking advantage of her statutory right to file claims within 2 years? Where is the harm to the school in that? They knew there was a 2-year statute of limitations.
All right. Thank you, counsel. Thank you both. We appreciate your arguments. Please accept our virtual greeting and handshake, and thank you for your arguments, and well done. And again, be safe in the weather, and thank you so much. Unless you say otherwise, I'll move on. You want, right? Good?
And if we can have both counsel for the next case, please both unmute and show your video. Thank you so much.
Ms. Napora?
Good morning.
Good morning.
May it please the court. My name is Chandra Napora, and I represent the relator in this Keatam False Claims Act case. And when, in our view, of course, when all allegations are accepted as true and all reasonable inferences are drawn in the relator's favor, as needs to happen at this stage, the particularized allegations that we've set forth put each defendant on notice that the defense needed a trial. The complaint should have survived the motion. We therefore seek reversal of the district court's grant of the motion to dismiss. And in the alternative, because amendment should be freely given, and this case is in its early stages of litigation, no undue prejudice would obtain. A proper application of the court's Rule 15 standards compels reversal of the district court's decision on our motion to amend, and we would seek reversal there as well. I want to cut right to 9B, as I imagine that's the most fruitful discussion. And just last year in Wheeler, this court underscored there are two paths an FCA relator, a False Claims Act relator, can take to satisfy Rule 9B. The first, of course, is to detail the who, what, when details of specific allegedly false claims submitted. And this, of course, is to foreclose the possibility, for example, that a claim was written off instead of submitted, as this court recognized in Grant. So just to be clear, while the court in Wheeler last year highlighted that there are these two paths, one, of course, detailing the specific false claim, and the other, the setting forth the allegations of reliable indicia that necessarily leads to the plausible inference false claims were submitted. This is not a new standard articulated by the court in Wheeler. This has been the state of affairs in this circuit, in every other circuit. There's not a single circuit in the country that requires, a staple of the claim to the complaint. But here the complaint walks both paths. And in the first, of course, the admitted complaint contains attachments of actual paid claim lines for claims where the underlying transactions violated the Stark Law and or the AKS. And of course, the violations of the Stark Law and the AKS that are detailed in the complaint provide the falsity element of the False Claims Act, and the claims submitted, the paid claim lines attached in the appendices, dispel any doubt that the claim was written off instead of submitted.
Can I ask you to explain this, because at no point have I figured out from your complaint or anything else what this is. On JA 144, can you just take the first line and walk me across what these things are, to help me understand how this relates to an alleged false claim?
Sure.
Well, I understand the far left column is about de-identification, so that doesn't matter.
Right.
The second line, the second column, that's who the billing entity is?
Right, that's the billing, yes, Your Honor,
So
that's
that
the
would be
billing
the-
provider. So in this
the
case,
practice?
it's THSPP. So
Right,
that's the billing entity.
Right?
I'm so sorry.
And then the third one, Mr. Chapman, or Dr. Chapman, excuse me, he's a THSPP doctor.
He is paid part of his compensation. He's on paper employed by THSPP. A part of his compensation comes from the hospitals. But he is a physician who the complaint contains allegations regarding his improper compensation arrangement with the hospitals
You just asked me who he is. I'm trying to read
AKS
the
allegations.
chart.
But yes.
I'm trying to read the chart.
Mm-hmm.
You can make the argument when we finish the chart, but how about help me read the chart rather than make the argument, all right? So the next one is also a doctor, as you've just described in detail, similarly situated, John Manning.
Mm-hmm.
Is that correct?
Yes.
Okay.
He's he appears to be the referring provider referred to Dr. Chapman, and I can speak more on this. This
I
information
just want to
is
understand the
directly
chart.
from CMS. I'm sorry,
and
what?
then the place that it's done is at THS Physicians Partner. That's the same thing as THSPP, right?
Right.
Okay, and then the next is the date, right? So that's easy. The CL procedure code 5,200 or 52,000, excuse me, is a particular procedure. This one's a endoscopy, but doesn't matter what it is. And then the amount paid and the date the claim was submitted and the date it was paid.
Right.
Okay, so just to put your allegations in context for me, for this claim that's identified, tell me where the hospital is involved. Like why is this like on the list? Because I'm not understanding where the hospital is involved. What am I missing?
Well, two things. One, we allege both Stark-related claims, which of course Stark prohibits the submission of claims by the hospital, for services referred by the incentivized physician. So, and we also allege.
This would not be relevant to the Stark claim because there's no allegation on line 1 that the hospital submitted any claim or made any claim with respect to this service.
So with respect to this particular service, from this information that is provided here, we do not see that this service was provided at a hospital, and therefore we would consider this to be an example of a paid claim relating to our AKS allegations, and which are not dependent, of course, on.
So maybe then, like, help me a little bit. How am I supposed to understand all of this? I mean, maybe that makes sense. I'll have to go back to that. How am I supposed to understand any of this from the complaint as to who's a defendant and what they're doing? I mean, I'm just having a little hard time deciphering, okay, that line's to the AKS claim. Maybe you think the 5 lines down, it's related to the Sturt claim. This just seems like a mash of information. It's like a data dump. It's not a claim that's articulated with particularity. And that, help me just with respect to the appendix. I understand you maybe, provide some context from the complaint, but these claims don't seem to do anything for me. I guess I'm just confused, perhaps.
So it sounds like, so I think your question is like, how is the court supposed to know how to read the appendices? Or okay, and I think respectfully, the question is, for 9B purposes, right? How are the defendants supposed to know so that they can prepare a defense? And
I agree. They're a lot smarter than I am, but we're judges, and so we sort of have to evaluate that question.
Absolutely, and the claims data that's provided here speaks to the who, for example. You've got the physicians that we've discussed in the complaint, and again, for a complaint, for a 9B analysis, the complaint has to be read as a whole, right? So the appendices in a vacuum are claim lines, but if you tie them to the allegations of falsity in the complaint, then you've got the who, which is the incentivized physicians. You've got the what, which are the CPT codes and that. You've got the when, which are the dates of service. You've got the amount paid, and which, by the way, isn't necessary, right? Because of course, in the False Claims Act context, the violation occurs when the claim is submitted, whether there's anything actually paid or not. And then you've got the where, meaning either in the physician's office, as you noted with Dr. Chapman there, or certainly if we go down the line, there are multiple examples. We can go down to the next one down on the Thomas Hospital that occurred at a hospital, right? So that claim would, because it occurred, we know that it occurred at the hospital, is necessarily going to implicate a hospital claim. And by the way, the defendants do not dispute in any way, at any point, that the hospital submitted claims for the services, for DHS services provided by these physicians. And they could not legitimately make that claim because their entire compensation structure is premised on the hospital generating revenue from the physician's referrals. And so there's no dispute. So whether like we can assess claim by claim by claim, could we provide, I was thinking about this, like how to provide the clarity that seems to be, eluding the district court and possibly this court, and in an amendment. And so would it be charts? Would it be like this doctor, this claim, this possibly? But I keep coming back to.
Can I ask you that question then? So like I totally get that, like I can't figure out how to provide clarity either. But when you talk about the amendment, like you're sort of saying it's impossible for you to figure out what the amendment would look like. How is the district court supposed to figure out what the amendment would look like when you didn't file a proposed amended complaint? Like you wanted it to address the amendment issue without telling what you've currently described as like an impossible answer?
Please allow me to clarify. I sorry to interrupt. I don't see it as impossible at all. In fact, I think that what we have provided we've presented, first of all, there's no requirement that we provide every detail under the sun to satisfy 9B. And we just, I cannot understand how, when you look at this court's jurisprudence in 9B, I cannot understand how, when we've satisfied the concern and grant that that a claim was actually submitted, and we have provided reliable indicia such that the only reasonable inference is that false claims were submitted. That how could a finding that this complaint with that level of detail, with the defendant's own documents, with emails, with board meeting minutes, with contribution management reports, where they are expressly and clearly tracking the referrals, the value of the referrals from these physicians to those hospitals, and they are subsidizing, they're paying these physicians above fair market value and offsetting that with the hospital revenue. I just struggle to understand how the court could find in Wheeler that the complaint there satisfied 9B, but here it would not. So when I say I've been trying to figure out how to convey, to answer the district court's confusion, certainly I don't find it impossible at all. What I do find it is a standard that is required not even at trial. So it would be the creation of demonstratives or summary exhibits or a closing argument, that kind of chart that we would use at trial. Here it's a pleading standard, and could those charts provide clarity? Probably. Are they required by this court's jurisprudence? No. There's cannot be squared. In fact, if this complaint with actual paid claims data and coupled with detailed information from the defendant's own mouths, if that can't satisfy either route, then it seems to me it becomes incredibly difficult as to draft any kind of False Claims Act complaint that would satisfy those either route. Because what we, as folks who draft these complaints all the time, what we hear from the courts are, you've got to show us that a claim was submitted, not that it was paid with cash, not that it was written off, not that, they decided at the last minute not to bill the government. And you can do that either by showing us specific false claims, or you can show us by alleging, as and I can refer the court to the Bookwalter opinion in the Third Circuit, which really kind of laid out this, this is not about a claim by claim by claim by claim requirement. Instead, it's sufficient allegations of pattern of conduct that renders these claims false, with reliable indication that claims were actually submitted. And that's the court standard articulated. I see I'm running out over my initial time. The standard that the court articulated in Grant, in Nathan, in Nicholson, in Wheeler, and by the way, I just want to say this for purposes of 9B, and again, I refer the court to the Escobar decision of the Supreme Court that helps make the connection, if it's still elusive, to the information contained on the claims data, which is again these appendices, provide the who, what, where, when, and how of the claims. That's that the billing codes and the information provided in those claim lines was enough in Escobar. It should be enough under this court's 9B precedents, and we believe it's enough here.
Councilman, just one question I have of you is that, are you saying that if a physician, I guess I'm a dinosaur in terms of all this language, but we would call it basically a lawyer, the doctor sort of has privileges in a hospital, is called. So if the doctor only has one hospital where she has privileges and therefore refers all of her work to be done, procedures at that hospital, and their bills are submitted by the hospital, are you saying that would be a stock? Well, that's because they have a relationship with that hospital?
No, we are not arguing, and the complaint does not allege that that an employment relationship. So just as a written, sort of generically violates the Stark law. Certainly not.
That may not be employment. Whereas the doctor has her own group where she's employed with, and the referral is through privileges. So again, that's outside the context of. So you're saying that could be a Stark claim, right?
No, I'm sorry, I misunderstood. No, so you're talking about a situation which is not present here in this complaint, where we're of course
We're trying
not
to understand
alleging.
what a Stark claim is, because you're saying they're incentivized. That's the only because they're incentivized, meaning if they can come over the quota or the minimum they get, or just if they meet the minimum and never get incentivized, is that a Stark violation too?
So that Stark is violated where the physician is in a position to financially benefit from referrals made to the hospital. So that can happen either with like a direct compensate. It can happen with lease agreements. It can happen with ownership interests. But here we're alleging it happens because there's a direct compensation arrangement between which by the way the defendants did not dispute, between the hospitals which fund the physicians' bonuses, which are based on productivity, which they get credit for other people's work. So it incentivizes, so the incentivizing comes in and incentivizes it. Basically, the more RVUs they generate, the more money they make. How do they generate those RVUs? So they're in it is by getting credit for other people's work, et cetera. And it results in above fair market value compensation for many of them. And so there's this compensation relationship where the physicians financially benefit from the revenue of the hospitals that they generate for the hospitals. Now that's where the Stark issue comes in. So in a situation as Your Honor's describing, where you don't have that, you're not in a situation where the physician who is not in a position to financially benefit from the referrals they make to the hospital, then Stark is not implicated. And then that's not the world we allege here.
All right, thank you. All right, go ahead, Mr. Honey.
May it please the court and counsel. First, I'd like to thank the court for doing these remotely. I know it's less than optimal, but had it not, I would probably be sitting in an airport somewhere between Chicago and the East Coast, frantic and nervous and helpless. So I thank you for that. I'd like to start with Rule 9B. There is no question this complaint failed to meet the requirements of Rule 9B. It lumped defendants together repeatedly without identifying what any defendant did. Appellant relies upon case law that says the word defendants is not fatal, but that case law goes on to say it is not fatal where all of the defendants are alleged to have done the same thing. All of the defendants are not alleged to have done the same thing in this case. Doctors are alleged to have made referrals. Mr. Ullery is alleged to have created a scheme. Hospitals are alleged to have billed for referrals, and the hospital system is alleged to have been a paymaster. These are not alleged, they have not been alleged to, they are not all alleged to have done the same thing. Therefore, the failure to differentiate is from the start fatal to the Rule 9B.
Didn't you just tell us what everyone's alleged to have done separately? You just told us that Mr. Ullery's alleged to do one thing, hospital something different, the paymaster something different. So, and that's in the complaint. All of these individual, they're not lumped together for those claims. So how is that not specific enough?
So when you get to the specificity required under Rule 9B, who did what? It is not identified who did what. It is not identified when they did it. It is not identified what they did. It is only discussed in gross generalities.
Well, it's not only discussed in gross generalities. I mean, the district court pointed to a few paragraphs where they refer to defendants as some or all of the defendants in a way that might be confusing, but there's many, many more paragraphs that refer to each of the defendants individually. They quote the individual defendant. There are dates when these things happened. There's meetings when they happen. There's, we can all tell what the alleged scheme is and who's doing what. I don't follow the argument that because they referred to defendants in gross a couple times, that now we can't understand what's going on.
Thank you, Judge Rushing. They do refer to the defendants as gross most of the time, but when you get to the Rule 9b requirements, the submission of a claim, who submitted a claim? Who submitted a claim which was false? Who did the things
Isn't that the charts? I mean, didn't we just go over the charts for who submitted the claim is
Yes.
here, the billing provider, isn't that who submitted the claim?
The charts, thank you, Judge. That was my next point. And the answer to your question about the charts is found on page 31 of appellant's brief, in which they confess that the charts do not identify a single claim submitted by a hospital. I'll go through the charts. As Judge Richardson asked, the charts show...
Why is that a particularity problem? Isn't that the whole argument here, particularity?
Yes, yes. If there is no claim submitted by a hospital, there's no Stark violation and there's no anti-kickback violation. The relator, the appellant in this case, is asking us to assume that a service...
That might mean that maybe you have an argument that they failed to state a claim because the hospital is not alleged to have done anything that violates the law. But that's different than an argument that it's not stated with particularity, right? Just so we're clear.
It is both. It is both, and it is a failure to plead what the hospitals or the defendants did with any particularity. And if they can't allege a claim by a hospital, then they can't allege a violation by the physicians because there's no Stark violation. They can't allege an anti-kickback violation. The relators admit that those charts don't include a single claim submitted by a hospital. And to try and get around that, what they're trying to do is expand the plausible inference language in Wheeler to say that you can plead 9b by plausible inferences in their entirety, thus consuming Rule 9b. Wheeler was a very limited decision. Wheeler said, if a plaintiff in a fraud case pleads the underlying fraud with particularity, step one, and that necessarily leads to the plausible inference that they submitted a claim to the government, a whistleblower who doesn't have access to the claim submitted to the government does not need to produce. In this case, though, they would ask to expand Wheeler to say, if we can plead the underlying fraud by plausible inference, that might lead to one of many plausible inferences that a claim was submitted to the government, then we've met the requirements of Rule 9b. If Wheeler is expanded to that extent, Rule 9b ceases to exist, and it can't be expanded to that extent because it's limited by Ashcroft versus Iqbal, which states that where the well-pleaded facts do not permit the court to infer more than the mere possibility of misconduct, the complaint is alleged, but it is not shown that the pleader is entitled to relief. So, going to specific types of examples, first of all, these exhibits, there's a question whether these exhibits should even be considered by the courts. Exhibits attached to a complaint should be considered where they're integral and explicitly referenced in the complaint. These are only generally referenced in the complaint. The entire discussion of the appendices says, Appendix A shows the claims to Medicare. Appendix B shows the claims to Medicaid. Appendix C shows the claims to TRICARE. So should they be considered? Probably not. Even if they are, what do they show? Appendix C doesn't even name a hospital. It doesn't show any claims by a defendant hospital. Appendix B doesn't name a hospital either. It says outpatient hospital or inpatient hospital, but doesn't name a hospital. Appendix A names some defendant hospitals, some non-defendant hospitals, visits to offices, visits at home, visits to long-term care facilities, but here's what it doesn't show. Claims by hospitals. Here's the plausible inference that they want you to reach to plead fraud with particularity, which is not what Wheeler says. And that is, if a patient gets service at a hospital by a doctor, they must have been referred by the doctor. Is that necessarily the plausible inference from these exhibits. Only if hospitals don't have emergency rooms or walk-in clinics. It is equally plausible that a patient seen at a hospital referred themselves. So from the get-go, from the starting point, they are asking the court to make assumptions, calling them plausible inferences, and letting the plausible inference language from Wheeler do all of the lifting instead of just the element of proving a claim submitted to the government. So the appendices don't get them there at all because by their own confession, they don't include hospital services or a referral to a hospital at all. Absent a referral to a hospital, there's no Stark violation, there's no kickback violation. Now, there are lots of other assumptions that the relator, the appellant, would have the court make. And they start with one which could not possibly be admissible. It starts with Mr. Ullery worked at a hospital in Florida that settled a False Claims Act case with no admission of wrongdoing. And he brought that fraudulent scheme with him to West Virginia. Now, that's not a factual statement. That is an assumption that the hospital in Florida did something wrong. It's an assumption that Mr. Ullery was involved in the wrongdoing. And it's an assumption that Mr. Ullery brought that wrongdoing with him to West Virginia. None of those things are facts. The next assumption that they would call a plausible inference and have do all the lifting, which Wheeler doesn't say, nor could it, is that there was a referral made every time somebody was at a hospital. And we know that that's not true because people go to hospitals when they're referred by a physician, when they're referred by a physician who's not part of Thomas Health, when they come to a walk-in clinic, or when they come to an emergency department. So we can't assume a referral. They want you to assume a referral by saying a doctor provided a service at a hospital. They also want you to assume that a hospital billed for a service just because a doctor performed a service at a hospital. So now we're breaking up the professional component of billing with the technical component of billing. But nowhere in here, even in their appendices, have they said, for example, that CPT code 99214, that's the fourth line in Appendix A, necessarily includes a technical component, nor does it, because 99214 is the CPT code for an established patient office visit at a moderate level of care. They've not even included in their exhibits what necessary technical component would be included. So they want you to assume that. Then they want you to assume that the hospital submitted a claim, though they've not shown a claim that could be submitted by the hospital, and that it was paid. And then finally, they want you to assume that the hospital payments, which went to support the physician practice, were kickbacks based on the volume or value of services, even though in their complaint, they admit that those payments were made based on a formula that did not include the volume or value of services. But why, they say, would the hospital or the system supplement this physician practice but for kickbacks? Because they wanted to keep OBs on staff and not turn Charleston, West Virginia into yet another maternity desert? Because they wanted to keep a pediatric oncologist on staff, even though they don't generate enough money to keep them on staff independently? There are lots of reasons hospitals subsidize physicians, and the fact that they admit that they were paid based on a formula, not based on the volume or value of referrals, is evidence they pled themselves out of their lawsuit. But wait, they say, these doctors were paid above fair market value. And how do we know that? Because they were paid within the range of fair market value. But some of them were paid at the high end of the range. So their argument is we've shown that they were paid above fair market value by showing that they were paid within the range of fair market value. The government itself has rejected that assumption as we as we wrote in our brief. They also say, but wait, the doctors were paid on a WRVU basis, meaning the more they did, the more they got paid. And we respond, right. That's how it's supposed to be. In fact, Medicare said when doctors are paid on a per unit basis and they are not paid above fair market value, it is by definition not a payment based upon the volume or value of referrals.
Can you respond to the argument that they also included NPPs that were, they say in 158, some of whom were employed by the hospital? Because obviously if they're employed by the doctor's office, it doesn't matter. But
Yes,
can you
absolutely.
address this allegation that their payment includes sort of conclusory at some NPPs who are hospital employees? They later talk about NPPs that are not hospital employees, but there's this general allegation in 158. Can you address that?
Absolutely, in 3 different ways. First, there's not a single reference to a claim that relates to an NPP anywhere in the exhibits as far as we can tell, so that fails under Rule 9B. Now, going to Rule 12B6, it's legally wrong. Doctors bill for services provided by NPPs under a concept called incident to billing, and I can give that to you in a very simple example. Patient comes to see a doctor, whether they're at a hospital and they see a hospital NP, or at their office and they see an office NP. The doctor says, you have a bad infection I can't treat with oral antibiotics, so you need to come in every day for the next 5 days and get an injection of wampicillin. Patient says, great, I'll be back tomorrow. The patient comes back the next 5 days and gets injected by the nurse practitioner. How is that properly billed? It is properly billed by the physician because the NP is providing services, and this is the legal phrase, incident to the physician's advice. So what's happening is, yes, the NP is doing the injection, and the doctor is billing for it because the NP is carrying out the doctor's services incident to the physician's services. That is how NP billing is done. Additionally, they have another claim that these doctors were paid for supervising.
Can I go back to that? So, fine, but I take your colleague's response to that, at least in part, to say, well, if the NP is employed by the hospital and the doctor gets the benefit of that incident to billing, that's a Stark violation. I think she would say that is itself a Stark violation. What's the response to that?
You would be incorrect because
Tell me why.
Because in all incident to billing, what the doctor is billing for is his or her medical decision making and advice. And whoever follows through on it is performing services incident to that physician's services. It doesn't matter where the NP is. The billing rule is if the services are being provided incident to, the billing entity is the physician who gave the advice and services. It doesn't matter where they are. That's not a Stark violation because it is all the services are still being provided is simply a follow-up to the physician's own services. And nowhere in their complaint or in their briefs did they attempt to explain how that would be a Stark violation, nor could they, because it is not. Additionally, physicians can be paid for supervision of NPs, and in fact, mid-levels in West Virginia are required by law to have a supervising physician. And physicians get paid for the services in their office as physicians, but remember, the money that they've included in their calculation of fair market value doesn't just include salaries. It also includes money physicians get paid for, and completely appropriately, for being the chief surgical resident or the chief of obstetrics at the hospital. And so they can get paid for supervising without it being a violation as long as they're getting paid as part of a written contract. I'm down to under 4 minutes, so I want to get to the futility just really quickly, as fast as I can. First, there's no second amended complaint. Even now, when it's being reviewed de novo, appellant has not given the court a second amended complaint to consider futility. But even if it did, it couldn't get there because their whole entire complaint is based on legal fallacies. Fair market value, which we've discussed, is still fair market value. WRVU payment is still WRVU payment. Now, they may say, but what about Toomey? What about Toomey, which found that they weren't paid fair market value and that's enough? Toomey's different. The key fact in Toomey was that the hospital went lawyer shopping, getting opinion after opinion after opinion, and many of which said this isn't fair market value until they found one that said it is. And that was evidence that they had knowledge payment wasn't fair market value, and that does not exist here. They've made no allegation of a meeting of minds for conspiracy. Reverse false claims cannot be a bootstrap to your underlying claims. They have to address something else. I've already addressed the NPs at Incident 2. And then finally, we get to the kickback statute. In the circuits that have addressed this, most of the circuits that have addressed this have said to identify and plead a kickback, you must allege but for causation. That but for the kickbacks that they were receiving, the physicians would not have made a referral. There is no but for causation here. There is no allegation of it. All they allege is that the physician's practice was subsidized by the hospital based on a formula that had nothing to do with the volume or value of referrals, but had to do with the costs and expenses. A perfectly reasonable and plausible inference, an equally plausible inference, is that was done to keep physicians necessary on staff versus there being kickbacks. So I don't believe the appendices should even be considered. If they're considered, the appellant has admitted they don't show any claims by hospitals, and claims by hospitals are absolutely essential for both their Stark and their kickback allegations. You cannot expand Wheeler to strike the words necessary and the, nor can you expand Wheeler to meet every single element of Rule 9b pleading, because remember, it said if you've pled your underlying scheme with particularity, and the only reasonable conclusion is that a claim was submitted, then you don't have to show claims. In Wheeler, there was a smoking gun. Therapy records were falsified, and the court said, what reason is there for falsifying therapy records but to support a claim to the government? Therefore, there is necessarily the plausible inference claims were submitted to the government. But what we have here is not a smoking gun, but steaming innuendo. The doctors must have made referrals to the hospital because they perform services at the hospital, although we know that that's not true. The hospital must have had some kind of claim they could have billed, in addition, some technical complaint, though we've not shown it. And therefore, the hospital must have submitted a claim, though we don't know if they even had one they could submit. And all of this was a kickback because maybe the subsidies to the hospital were based on the volume of value of referrals, even though we know they were not. This is a general scheme based on a fallacy that starts with Mr. Ullery in South Florida and leads to us here today. I thank your honors.
Thank you, Mr. Honig. Ms. Napora, you have time reserved.
Thank you.
Can you start with this idea of the WRVU incident to billing, that if that is done by a doctor, so a doctor goes over to the hospital and directs the shots that your friend indicated, and the doctor bills that NPP time as incident to their billing code, is that itself a Stark violation, and is that what you're alleging?
We are not, the complaint purposely does not speak to incident 2 and respectly.
Yeah, I know you're trying to avoid it, but what I'm saying is.
No, I'm not, I'm actually not trying to avoid it. Sorry, we're talking over each other. Not trying to avoid it at all, it's just not relevant here. It's not relevant here because when you look at when Stark require, in order to, first, I guess let me contextualize by saying all of what the defense counsel is referring to the extent that it's grounded in the complaint and or the law, and I can come back to those in particular, speaks to affirmative defenses, which they have the burden on. And so if they want to come back and say, look, in fact, the services that the physicians were given credit for in the WRVU assessment, which again goes to their compensation, they get bonused based on their productivity. Their productivity is assessed by the productivity of others, and so it's not personally performed services. So which it must be under to qualify for Stark exceptions, right? But the Stark exceptions again are their burden once we make the prima facie case. So the incident.
But your responsibility is to make with particularity a plausible allegation that on this particular issue, that, you know, their compensation for WRVUs from NPPs are somehow illicit referral payments and not permissible supervision or incident to billing. I mean, that seems like the sort of Twombly idea, right? Like, it could be that this is, you know, illegal antitrust conduct, or it could be just sort of like standard action. And like, what I can't tell from the complaint is why I picked between one or the other.
So let me speak for a little bit on WRVUs, because I just think there's some confusion here. As the complaint alleges, and I can, you know, JA 92, paragraph 18, the physician compensation plans at issue here included a base salary. And again, we're only in Stark world right now. And I just want to flag for the court that many of defense counsel's references to the AKS represents sort of a blurring of the two statutes. The AKS, the question for the court on the AKS is whether the complaint alleged that at least one purpose of the remuneration provided was to induce referrals. It has nothing to do with the volume of value of referrals. That's a Stark analysis, and I just need to highlight that so that that confusion that the defense has interjected gets cleared up. But back to Stark, the physician compensation plans at issue included a base salary and incentive compensation, right? They're both tied to WRVU numbers. The physicians were required to generate a minimum number of RVUs, which were specifically identified in each contract per year in order to earn their base compensation. And then their incentive compensation was calculated by applying a set dollar amount, which is the conversion rate, which you see referenced throughout the complaint, per WRVU generated in excess of the base. And so why is that? How does that go to?
Now, can I pause for a second, just so I understand what your story is? But you agree if the only WRVUs that were included were the physician's own time treating patients, that would be perfectly acceptable. That's not a Stark problem at all.
With the caveat that if the conversion rate was not a sort of, as we allege that it is here, the conversion rate were not a sort of disguise to artificially inflate the compensation. Because, and this goes to this issue of whether the hospitals are subsidizing the physician salaries in exchange for referrals, which they are. And how do we know? Because, for example, the Medicare conversion rate per RVU hovers around about $35. The defendants know this. They know all of this. They track all of it. So here you have physicians who, for example, Dr. Joe Campali, who is receiving a conversion rate of over $100 per RVU. And so, and his RVU numbers were off the charts. So there's no, we're looking at WRVU numbers that suggest either borderline medically impossible days. That there's no way that a person, like a physician personally could perform those numbers of RVUs. And why is that tied to the conversion rate? Because for every WRVU that he reports, not that he performs, that he reports, he gets $105 per WRVU, which is how his compensation, and he's not the only one, reaches above fair market value levels, which is, again, fair market value is not an element of Stark. It's not an element of the AKS, but it suggests, and it's clearly, and this is clear in the case law and all the Stark False Claims Act case law, why would a hospital system pay physicians above fair market value if not to gin up their referrals? And all of the defense counsel's comments with respect to referrals respectfully are just disingenuous. The defendants tracked minute by minute almost what the value of the referrals to the hospital system and the individual hospitals was by these physicians. Hiring decisions were made on this basis, not based on whether they needed someone to provide in OB care in a maternity desert, but rather, or in addition to, whether that physician is going to add revenue to the hospitals. How
Can
do
I
they add
ask
revenue
you-
to hospitals and making referrals?
Can I
And
ask
it's
you
not a
to
referral.
respond to one of,
Judge Rushing has a question.
Yes, I'm sorry.
can I ask you to respond to one of the defendant's arguments? He said that you have admitted that nothing in the appendices shows any claims submitted by a hospital, and that is essential for a False Claims Act claim.
Yes,
You
thank you for
please
giving me that
respond to
opportunity.
that before you're done.
Absolutely. Yeah, I love to respond to that. It's just not true. It's true that we have the claims that we set forth are not hospital claims. We didn't have access to those claims until after the district court's order. And so we flagged for the district court. If that is necessary, we can provide it an amendment because we now have access to those claims. We do not believe that is what 9B requires because the complaint sets forth the billing processes. And again, this goes back to Escobar, goes back to the pleading standards for particularity. I can refer you to the JA 76, paragraph 57, 58, 59 through 67, which detail how the interrelationship between physician claims and hospital claims. So, and we set forth the billing processes in the complaint. The defendants certainly know what those billing processes are. And so to the extent that there are claims that occurred in the hospital, in the physician office setting, again, we've addressed that earlier, but if we're talking about claims that were submitted where the service occurred, the service, which is a referral under the Stark Law, and again, referral has a particular meaning under the Stark Law, not the one suggested by defense counsel, but if the service is performed at the hospital, then we know, and we certainly have alleged with particularity and the only reasonable inference, again, because defendants don't even dispute that that hospitals submitted these claims, and in fact, tracked them closely. This was the purpose of the scheme, was to gin up revenue for the hospital.
I'm sorry, I am trying to understand your response. There's a factual and a legal component, it seemed to me, to what the defense counsel said. He said, nothing in the complaint alleges a claim submitted by a hospital. There's nothing on these charts that's a claim submitted by a hospital. That's a factual statement. And that is required to state a claim. That's the legal statement. Do you disagree with one or both of those? Or are you admitting, yes, we don't have any claims by hospitals, but we could get some, and yes, they are required?
Probably the latter. So we do not include any hospital claims in the appendices. Again, we didn't have access to those. Rule 9B does not require that we do. This is to require
Does
that.
the False Claims Act require that you do? I mean, to state a
but we've alleged that they were submitted. So the False Claims Act, sure, yes. I mean, what we allege and what the complaint sets forth is that the hospitals submitted false claims to the government. How were they false? Because of the violations of the Stark Law and the AKS, and that Mr. Ulrey caused the submission of those false claims. So yes, it is required under the False Claims Act, and the complaint alleges that. What it does not require.
Can I ask
is that
where it alleges that? Because when I read paragraph 58, which I think is what you're referring to, it says when a physician provides the care, the physician bills for it, and the hospital may, not did or has to, but it says they may submit a technical or facility component. Okay, well, they may, but what we don't know is whether they did. I mean, that's sort of the point that we're getting at in the False Claims Act, right? The fact
we
that
absolutely know that they did. We absolutely know that they did because the
where in the
defendants
complaint do I
tracked
know that? Counsel, where
I'm
am I
sorry.
looking in the complaint to know that? I understand that you claim to know that as we sit here today, and that's helpful maybe to you, but where in the complaint do I see that other, I mean, maybe it's a different paragraph, but the paragraph that I think you just pointed me to says that they may do this, which reads to me that they may not do this too.
Well, okay, so fair enough. I think that where I sit with certainty that they submitted claims comes from their own documents, and particularly.
Give me a paragraph in the complaint.
Sure, the paragraphs that detail the contribution management reports, and I can let's see, point you to those in particular in just a moment. Well, if we look at the so JA 96 to 98, 122.
I can find the contribution management reports. If that's the portion you want me to look at, I can look at that when we're done. I know we're way over. Thank you, Judge Gregory. I appreciate your indulgence.
We have some that's on the tip of your tongue. Go ahead, but
I have much on the tip of my tongue, but I realize I'm way over time, and I appreciate the court's indulgence.
All right. Thank you, counsel. Thank you both for your arguments, and we, our normal custom, we come down and greet you. Suffice it to say, a virtual one would have to do, but nonetheless, we're very thankful for your work, and both of you, and be careful in this weather. I think it's
Thank you,
very
sir.
serious weather, and we appreciate you. All right, Mr. Jones?
Your Honor, and may it please the court, Mark Jones for Monte Strait. Today's categorical approach question is not whether completed armed bank robbery is violent, but whether an attempt to commit an armed bank robbery under Section 2113D, as defined by its element and as instructed to juries, necessarily requires the use, attempted use, or threatened use of violent force. The Taylor decisions from both this court and the Supreme Court, and this court's McFadden decision control the analysis, and the answer is no. An attempt to violate Section 2113D is not an attempt plus force offense. It is an inchoate attempt offense. And as such, an attempt to violate 2113D can be completed upon a showing of a substantial step towards threatening force. That is, the attempt can be accomplished without any actual, attempted, or threatened use of violent force. This court's longstanding precedents and the jury instructions that were given in the case confirmed that Mr. Strait in particular was convicted of an inchoate offense attempt. So in the circuit, we have McFadden, and McFadden interpreted the word attempt as used by the Congress as Section 2113A. And in McFadden, this court said that attempt there in unarmed bank robbery means an inchoate attempt, not an attempt plus force offense. Likewise, Congress included attempting in Section 2113D, but this does not mean that attempt when it occurs in this subsection now means an attempt plus force offense. Rather, Section 211D offense, like 2113A, is an inchoate offense.
Didn't we address subsection D in McNeil? And we laid out sort of 4 elements, and we defined this element that you're talking about as, so it's basically a violation of A, and then in committing or attempting to commit that offense, the defendant assaulted a person or put their life in jeopardy with a dangerous weapon. So doesn't that cut against your argument that it only needs to be an attempt to use the dangerous weapon? We kind of defined the elements differently in McNeil than you're defining them now.
I don't think so, Your Honor. I don't think McNeil is helpful to the government here because McNeil was talking only about a completed armed bank robbery. And what it looked at necessarily was the lesser included, which was completed unarmed bank robbery. And what it says is that because a completed unarmed bankery does have this violent element to it, the greater offense will also be a crime of violence. It does not specifically address the language of subsection D. It does not specifically address attempts either of subsection A or of subsection D. So I don't believe that McNeil controls this analysis. I think one of the problems the government has is similar to what happens in Vine's case. There are a number of circuits that say 2113A is an attempt plus force type of crime. And on that basis, those other circuits say subsection D, attempted armed bank robbery, is also an attempt plus force crime. But that's simply not the jurisdiction in this circuit because of McFadden. And more importantly for Mr.
We haven't addressed this question though, right? I mean, we've addressed whether A is attempt plus force or however you're describing it, but we haven't addressed how to interpret the text of subsection B, which is written differently than A. B is, seems to much more clearly say, whoever in committing or attempting to commit an offense defined in A uses force or threatens force or attempts force.
So 2 responses. I think that's my answer also in response to McNeil, is that McNeil did not interpret 2113D or the attempt language in that case. But there's nothing in the language of subsection D that would suggest that when Congress used attempting in one subsection, it means something different than when it used attempt in the subsection 3 before it. We know what attempt meant in subsection 2113A. That meant an inchoate attempt offense. See McFadden. The text
Well, it's just they're written differently. I mean, A puts the force and violence and intimidation before taking or attempting to take. Subsection D puts it after. I mean, your argument seems to be that because this court interpreted A a certain way, we're required to carry that over and interpret D in the same fashion. But I don't follow that. Why wouldn't we just interpret D according to its text?
So we know what Congress said in A and in D, and it's the same, it's the word attempt. And so the question is, why would, if written as attempting, instead of as written as attempts in subsection A, why would this court give essentially the same word different meaning when it shows up 2 subsections apart? And that's the argument, is that...
Yeah, but one answer to that is because we got it wrong the first time, right? One answer is like, okay, we're bound by that, perhaps with respect to A, maybe. We can debate that. But one answer is it was like egregiously wrong. And so we are bound by that as a panel, but we are not bound to apply that to the ends of the earth. Right?
So,
why isn't that sort of the response to the point on D?
So I think certainly this court could say that McFadden doesn't control the analysis or the textual analysis of subsection D. But I think the force of McFadden and its reasoning and what the statute was doing is important. I mean, the court in McFadden was talking about why there are attempt offenses, what's different between the attempt offense and what the government is arguing now, and that the purpose of attempt liability was to protect people, that people did not have to wait until there was force or violence before there was liability underneath the attempt. And so the same...
Those are all, I understand that that's what the court said, and those are all great reasons for, Congress to write a different statute, right? But none of those address, the actual language of the statute. And so, it seems odd to take those policy arguments and say, we got different, although maybe vaguely similar text, and so we're going to, import that egregiously wrong decision into this other statutory provision, even though it's different and in a different context.
So I think the answer, perhaps, in Your Honor, lies inside what the Supreme Court and what this court said in its 2 tailored decisions. And what makes a difference about Hobbs Act robbery and about bank robbery and about armed bank robbery is that they can be accomplished by threats. They don't have to be accomplished by actual force or completed force. The Taylor decision spends a lot of time talking about how it is because it can be accomplished by threatening action that the attempt liability does not mean it's a crime of violence. And so, for example, this court said in its Taylor decision, quote, "We have repeatedly held that certain crimes of violence, like Hobbs Act robbery and federal bank robbery, may be committed without the use of attempted use or physical force because they may be committed merely by means of threats." And the Supreme Court, in its Taylor decision, further explained that to threaten the use of physical force was neither the attempted use or the threatened use of physical force. I don't think there's much dispute that intimidation, when it's used in 2113A, means the threatened use of physical force. And there's nothing about subsection D that alters that. The threat of physical force can be from anything, including a firearm. The text of 924C4, which relates to brandish, describes brandishing as intimidation. This court's decisions in Gross and in Whitfield, and these are, in the government's brief, all talk about how brandishing a firearm or even having a firearm there it is intimidation. And in Whitfield, this court even noticed that the act of brandishing a dangerous weapon can support a completed 2113D offense for putting another person's life in jeopardy, but it's still only threatening the victim. And so an attempt to threaten the victim does not require violence. The other thing that's important to note in this case is that there's no doubt that Mr. Straight his jury was instructed on an inchoate offense type.
But unfortunately, that's not the question we're supposed to ask, is it? Unfortunately, we're supposed to be asking, in a hypothetical world, what could the least culpable person have been convicted of, regardless of what this gentleman's jury convicted him of, right?
I think that's right, and what we know is that his jury, as a real person who I think sits inside the hypothetical, was allowed to be convicted on the basis of this inchoate language. The government in the red brief at page 4 provides jury instructions, but the jury instructions that it's reproducing are those of counts 1 and counts 2. The jury instructions that Mr. Straight's jury got are on page 39 and 40 of the joint appendix, and that's where this court said, you can convict him even though nobody did all of the acts necessary to commit the offense. I said in the blue brief, this argument has been sort of analyzed in depth by the court in Vines. And I think the dissenting opinion there by the chief judge has the better of the arguments.
Has any circuit court agreed? I mean, has any circuit court held that attempted armed bank robbery is not a crime of violence?
The DC Circuit and the Ninth Circuit.
They've held that attempted violation of D is not a crime of violence. Is that what you're saying?
I believe that's correct, Your Honor. The government cites to the Ninth Circuit decision in the red brief, and the DC Circuit, I believe, reaches that, although it takes a different path. It says that the first prong of bank robbery between extortion and robbery are indivisible, and it fails because extortion is not a crime of violence.
Right,
So,
and you didn't really make that argument here. I know you had a heading about it, but you didn't tell us why we should disagree with our precedent and make that whole.
No, that's correct, Your Honor. I included that, should this panel have felt constrained by the reasoning and logic of McFadden, and such that an en banc court would be required to reverse McFadden and clear the path here, I wanted that argument out there to be able to make that pitch to the whole court should it have gotten there. I don't see McNeil as supporting the government's case in the way the government thinks it does, precisely because what I said earlier, because it is not specifically interpreting 2113D, and there's nothing in the text of 2113D that specifically requires, for an attempt offense, that violent conduct occur. I've argued additionally that there's a problem with the language. It is categorically overbroad. For the force and elements clause to apply, it has to be that the force was applied against the person of another. And subsection D clearly was not written with that stricture in mind, because it does not limit itself to force against another person. There's also a Borden problem, because while this court in Carter and other courts may have talked about the mens rea for subsection 2113D, if everything is being hung, 2113A, if everything is now being hung on a textual analysis of 2113D, there is no mens rea that's connected to that specific provisions. And so I do believe, even if this court were to say, McFadden we think was wrong, but we can go in a different direction because we're only looking at D now, we still have problems with overbreadth because of the language any person. And I think that for those reasons, the court simply can't affirm the district court here. I do think McFadden sort of controls the area, because the analysis really does look at what was Congress trying to do when it talks about an attempt. This may, Judge Rushing, circle back to a point that you've made about what the question is here, but I'll also say that if you look at the specific indictment of Mr. Straight, which is on page 28 of the joint appendix, it doesn't pick up the word attempting from subsection D. It only includes the word attempt from subsection A. And so if there is any attempt liability for Mr. Straight, it comes from 2113A here, which, as McFadden said, is an inchoate attempt offense. If there aren't any questions, I would reserve the balance of my time.
Thank you, Mr. Jones. Ms. Niemeyer?
May it please the court, Julie Niemeyer for the United States. The district court correctly determined that attempted armed bank robbery in violation of section 2113D of Title 18 remains a crime of violence after Taylor. This is because its fourth element requires, at a minimum, the threat of force. Both the text of the statute and the case law of this circuit counsel this result. I think the fundamental disagreement between my friend and I here is the characterization of 2113D as an inchoate offense. The text of 2113D establishes that it is laying out the elements of the statute in the text of the statute itself. And in that regard, I would call it a statutory attempt offense. We saw this language in Judge Gregory's opinion for the court in Hamilton, which drew a distinction between an attempt offense that is very narrowly defined right in the text of the statute versus an attempt offense that is not defined, which has to then be defined under the common law principles of intent and a substantial step. That's the type of offense that we were looking at with attempted Hobbs Act robbery. And that's why we got to where we did with that determination that it could be accomplished by an attempt to threaten, and so would not be violent. But that's not what we're looking at here. We're looking at a very clearly written statutory requirement that in attempting to commit the offense, the defendant assaulted any person or put in jeopardy the life of any person by the use of a dangerous weapon or device. The statutory text does not criminalize an attempt to threaten by use of a deadly weapon or device. The attempt comes in the first element, the 2113A element, whether the defendant took or attempted to take the money of the bank. In specifically referencing committing or attempting to commit the offense that's mentioned by reference, the 2113A offense, the statute identifies the D element has to be completed. In the act of attempting that offense, the defendant assaulted any person or put in jeopardy the life of any person. And that's what makes it a completely different type of statutory offense than Hobbs Act robbery. I think it's also helpful to look at some of the other decisions in this area that involve an aggravated penalty provision for the use of a weapon. We have very similar statutory schemes in 2114A, for example, dealing with assault of mail carriers, which calls for a certain penalty for not using a weapon, but then in the enhanced penalty provision criminalizes in effecting or attempting to effect such a robbery puts life in jeopardy by the use of a weapon. So by putting life in jeopardy by the use of a weapon, this court determined that that was, at a minimum, the threat of force. And so necessarily that aggravated version of the offense is a crime of violence. Very similar structure.
Counsel, but in this case, it's a little different, isn't it? Does being armed add anything to the threat? Wouldn't this be completed if the person had a weapon in their pocket and threatened to use for armed robbery? It doesn't require using it. It's armed. It's armed, isn't it? So if they never, it's a hypothetical in this case, but let's say they went into the bank and had a gun in their pocket and they said, listen, I'm going to rob this bank and I want, I want the money. I'm threatening them. I want the money. This could be dangerous to you if you don't give it to me. And then before they get out of the bank, the police arrive and they're arrested for attempted robbery. Well, then the gun wasn't used at all, but they were, right?
If I'm understanding that example correctly, Your Honor, I think in that case, it would hinge on whether the weapon was truly used. If the weapon is hidden from everyone and no one in the bank is aware that there is a weapon, then I don't think that would meet the definition of assaulting by use of a weapon. If the weapon was not visible to anyone.
You said the elements are laid out in D. Where does it say you have to use the weapon?
That's in the text of D, in that it says, whoever in committing or attempting to commit any offense defined in subsections A and B of this section assaults any person or puts in jeopardy the life of any person by the use of a dangerous weapon or device. And so I think the use aspect of that language is what makes it, at a minimum, a threat of force. And Your Honor,
attempted threat of force? Attempted threat. Right?
That wouldn't be I'm sorry, if I said that I misspoke. The threatened use of force is, at a minimum, present in Section D. So really, the offense in 2113D should be called armed attempted robbery, because the armed portion of it is not, cannot be committed by an attempt. That's a requirement. It is the taking that is attempted. I'd like to address just briefly counsel for Mr. Straight's reference to the jury instructions. The government does candidly recognize that those jury instructions did use the phrasing of an intent and a substantial step with respect to count 5. However, the indictment itself, the indictment language, which is shown on JA 28, very clearly tracks the language of the statute itself. So to any extent that the jury instructions did not precisely track the language of the statute, of course, which is not at issue here, even if those instructions could be considered in some respects error, that could still be harmless error, even if that had been properly raised. When a person looks at the indictment language being very clear, and then, of course, the evidence that the jury saw here was the evidence that the defendant approached the bank and brandished firearms. So I'd also like to just briefly address counsel's argument regarding the mens rea requirement for 2113D. As we saw in McNeil, it's very clear that 2113A is a general intent crime. The defendant must know that his actions are objectively intimidating at a minimum to accomplish that offense. So he has to have knowledge with respect to the act that he is committing. That itself is incorporated into element D when element D requires that in attempting to commit the 2113A offense, the defendant assaults or puts in jeopardy the life of a person using a weapon. That intent can't be divorced from what the defendant is doing in element D. I think also it's important to recognize some of the language in the Lassiter opinion written by Judge Richardson for the court, where he pointed out that the force clause doesn't require, quote, the forcible attempt to use force. So this court does not need to reach the McFadden question here, but even if it were to do so, an attempt to do a violent crime does not necessarily have to be violent itself. But again, here, since we're looking at a 2113D offense, we're not talking about an attempt to do the action that is set forth in element D. That has to actually be completed. The assault or placing in jeopardy has to be a completed act. And again, in the Hamilton opinion, I think it's useful that the court identified that both an inchoate and a completed offense can be side by side in the same statute. So here, even if this court does leave 2113A in its inchoate form, that's not inconsistent with recognizing that commission of a 2113D attempt offense is not an inchoate offense. It has clearly defined elements. If there are no other questions from the panel, the government would ask the court to affirm the decision of the district court that attempted armed bank robbery remains a crime of violence. Thank you.
Thank you, Counsel. Ms. Nehemiah. Mr. Jones, you have some time reserved.
Thank you, Your Honor. So just a little bit about the framing. The government sets this up as whether or not attempted armed bank robbery remains a crime of violence, but this is a question of first impression. It's not whether or not it remains, it's whether or not it is. And one of the things the government does as to a number of arguments that we make is it says, well, the attempt is about the taking, or the attempt is about this, and it looks to other parts of 2113 when it talks about mens rea. But if we're going to interpret any of those other prongs of 2113A, we have to look at what McFadden said. We can't divorce McFadden from an interpretation of 2113A. And we can't then, we're stuck at looking at just what 2113D says all on its own. And I mentioned earlier the dissent in Vines, and I draw the court's attention back to that, and it's discussed in my brief. But what the Chief Judge there says is that even looking at the language of 2113D all on its own, there's no reason to interpret that as anything other than an inchoate attempt offense. There's nothing about the structure or the language there that says it is an attempt plus force, completed force offense. And the dissent makes points of looking at the chart that was provided by the majority in Vines and by the government in this case, which is really an analysis of 2113A. It's not an analysis of 2113D. And so this court, I think, would be all on its own among the circuits in analyzing just 2113D to say that it is now an attempt plus force offense. All the other circuits have reached the conclusion, where they have reached the conclusion that it's a crime of violence, by first recognizing their circuit precedent, the opposite of McFadden, that attempted armed bank robbery was a crime of violence. And so I think part of the question is, why would Congress have attempt mean one thing in one subsection and attempt mean something different in another subsection? But the specific language of the text is also problematic for the government because it says assault and it says any. And those sweep broader than the force clause of section 924C3.
Well, it's assault with a dangerous weapon, right?
Well, it depends on how you interpret it. It actually says
No, it's, the Supreme Court said that in Simpson, that this means, even though the commas are in the wrong places, the Supreme Court said it means with a dangerous weapon.
That's correct. We still are left with the any problem, you know, and the broader sweep. And what we can't do
Can a
is
person assault himself?
the
Like legally, can a person assault himself?
they can certainly put in jeopardy their own life.
But can they assault themselves?
I don't know the answer to that, Judge Rushing. Whether or not
I do. Right. You should know. Come on. You know this one. It's an easy one. I don't imagine you can legally assault yourself. And the argument is that then any person should mean the same thing in both places, right? It's your argument about the word attempt, right? It should mean the same thing in both places. And that if it's nonsensical to say assault yourself, then the same thing applies to putting your own life in jeopardy when you're using a firearm to rob a bank.
The other courts have not reached that conclusion as directly. A number of courts, including
No
this
court that I have found has really said much about it, right? There's been a few district courts who have brushed off this argument, but I haven't seen much about it.
This court, at least in McFadden, understood that a person who goes into a bank to rob it puts his own life in jeopardy. A number of places, courts have said that even going in with an unarmed weapon puts your life in jeopardy. And again, the Vine's dissent talks multiple times about how the defendant's life
Is
can
that
be.
something that we think Congress would be increasing your time in prison for? Like, we're going to give you 5 more years because you put yourself in jeopardy? Or is it because you put other people in jeopardy?
I think what we're looking for in the categorical approach analysis is whether or not the language that Congress used sweeps broader than the force clause. And the force clause is limited to who can be put in jeopardy. And 2113D, if we're looking at it standing alone, doesn't require that it be so limited. It uses the word any, and as we've heard earlier today, any is a broad word, and so for that reason alone, it sweeps broader. But I'll say again, I do think we can't just look at 2113D. We have to look at what this court has already held in McFadden, and that is that all the preceding subsections of the offense result in an inchoate offense, and that's how Mr. Strait was charged, and on that basis, he's serving an additional consecutive 25-year sentence. I would ask the court to vacate the decision of the district court and remand for further consideration.
Thank you, Mr. Jones. Mr. Jones, I note that you're court appointed, and I just want to give a special appreciation to you and other lawyers who take cases like this that the court really appreciates and depend on that. And thank you very much for your able representation, and Ms. Niemeyer, for your able representation in the United States. We can't come down and greet you as we would, but know nonetheless that we appreciate you very much and wish you well and be safe in this weather. Take care.
Thank you, Your Honors.
This honorable court stands adjourned until tomorrow.